And then she's outside for like 8 minutes and then comes back in.
Yes.
And then we have a pretty long sidebar, and you can see Miss Love is talking most of the time. She's holding a microphone. We can't hear it. And then we see Judge. It looks like Judge is looking at Love when he's saying something pretty tensely. And this goes on and on, you guys. This is a long sidebar. That was like a 20-minute sidebar. And then Miss Love gets into some questioning with Detective Gaither when Detective Gaither gets back on the stand. So they don't have any testimony from a witness present within this recording. They only have Gaither saying, "Oh, I looked at that post," which is not the same thing as someone having firsthand knowledge of when it was recorded, who was there, and what was actually said during that time frame. So when you hear mentions of Rule 901, and mind you, Steele is looking at the same cases that Love just used to make her argument, but Steele is bringing in this extremely relevant context to the appellate court's decisions that Love didn't include in her argument or even try to address. She just said, well, the trial court decided to bring it in, and the appellate court didn't want to disturb that. But here Steele's like, well, the appeals court, these cases, they let it in for a reason, possibly, because they actually had a witness with firsthand knowledge. And so in my opinion, Love was vaguely trying to say that, oh, Detective Gaither, her saying that she saw the post, the video go up on social media, was enough to meet the criteria for Rule 901, which means we want to be able to authenticate and identify an item of evidence. There needs to be evidence sufficient to support a finding that the item is what the proponent claims it is. Such as through testimony of a witness with knowledge, that the item is what it is claimed to be. Now, can Gaither give that knowledge? She could say it was a social media post, but can she say it was a video that was recorded on the day the social media post was posted?
And then it goes on to show.
That's plenty. All right, Ms. Steele, I'll give you the last word because it looks like I may have read too early. So.
I believe you read too early. Statement of a party admission has to be an admission.
Party opponent.
An admission by a party.
Admission shall not be excluded by the hearsay rule. An admission is a statement offered against the party. A statement means an oral or written assertion or a nonverbal contact of a person is if it's intended by the person as an assertion. Your client is allegedly making a statement in this particular video, which.
Well, then I didn't know about this when you broke. If I would have known about this issue, I would have done it over the break. I just learned about it. I'm assuming the court learned about the state's new position. I'd like time to look at it because my memory is this is not an admission. Abuse its discretion in admitting evidence. There's a paragraph explaining it and then goes into one.
Hold on 1 second, sir.
Okay. And then, it's a short passage. We can read the whole thing, but I liked it because it targeted both what you said, Joyce, and I heard what you said after I found it. But 801 D2A as well as 801 D2E, it was in the same case. And in the third paragraph of Division 1, it states that the district court also acted within its discretion when it concluded that circumstantial evidence coupled with Rodriguez's self-identification authenticated the telephone conversation sufficiently to satisfy Federal Rule 901, which is corresponding to Georgia 24-9-901, which provides that the requirement of authentication or identification as a condition precedent to admissibility is satisfied by evidence sufficient to support a finding that the matter in question is what its proponent claims. And that's what the court just found.
It is.
Your Honor, in regards to the statements of other people on that video, those are not admissions by Mr. Williams. So are those being redacted? I recall, despite what was said at the bench, that the tape actually, I think at one point someone says this is from YSL B word or something like that. And those are not words of Mr. Williams.
Okay, but Mr. Williams, if you believe the state's argument and the jury can decide for themselves, he's co-opting that particular person's statement as to the circumstances.
Well, and I have an argument about that. Essentially what we're talking about under the law is the case law refers to as an adoptive admission.